within these scenarios, and they are not drills which will endanger national security. So application can be submitted to the Secretary for Security for permission. Now that the list A to F is not exhaustive, so that's why we have added a clause that permission can be sought from the Secretary for Security or the Commissioner of Police, and that would exonerate the applicants of the owners. Dr. Low mentioned military boarding school. If you look at subclause 8 under educational establishments, we provide exemption to full-day or full-time schools, including university, college, school, or other similar educational establishments. But we do not include an educational establishment specialized in providing military training or drilling course. Now, if the school is education focused with just 1 or 2 sessions of drilling, that should be okay. But if a school is military focused or military school, that would be caught. So we have to look at the school one by one. Boarding school in the UK also offers non-regular military training, but that is on a voluntary basis. Students have to enroll themselves in these courses if they want to take part in them. So for conscription-based training offered to non-nationals, I think that is quite rare. Mr. Stanley, Chairman, I have some concerns about the scope of this clause. What if an organization is offering drills for color revolution? If they provide drills on civic disobedience, will that be caught? Second question. These drills would usually operate under a force banner. They would call themselves leisure activities. When they recruit trainees, they would tell them this is just a leisurely training. So how do we make a distinction between those real leisurely training and those fake ones? I think the name is not important. The substance of the training counts. No matter what banner you are operating under, if the substance is problematic, then you are guilty. There is also the question on the scope. So the point is whether the purpose of the drills is to endanger the national security of our country. That's the question. The spirit of the provision is that besides the exempted scenarios, for regular drilling or conscription-based drilling, excluding those, there are other scenarios where you may apply for permission from the Secretary for Security. Otherwise, the other drills are regulated under the clause. A follow-up question. There are some drills concerning colored revolution. They teach people how to pretend to be journalists to obstruct the police and also how to move the brakes and weapons. Will those count? Now we have a term specified drilling. There are 3 items under the specified drilling. For example, training or drilling in the use of an offensive weapon, that will be caught under the Public Order Ordinance. Second, the practice of military exercises. And 3, the practice of evolutions. So we have military training, but there is also evolution training, which falls short of military training. For example, changes in formation and so on. That's evolution training. So it depends very much on the substance of the training. So the color revolution, that is an umbrella term, but we would look at the actual actions done. Mr. Tony Jie. Thank you, Chairman. Unlawful drilling. I want to know more about this term. I think the government has given us a very clear explanation, and many of these actions are caught under subclause 5D. I understand that external force include those forces in Taiwan. I wonder if my interpretation is correct. So the point is unlawful drilling. When in concern, you just need to seek a permission from the Secretary for Security or the Commissioner of Police. So when in concern, approach them. Simple. Now, subclause 7, there is the time frame of 6 months. So why 6 months? What is your consideration? Which official? Thank you. I will invite Deputy Secretary to tell you why 6 months. Yes, the transition period, we don't want the transition period to be too long. Parents may have made plans for their children during summer holiday. So the intention was, in 6 months after the passage of the bill, the transitional period would cover the summer holiday as well. So parents and students can stick with their original plan, and it would be more convenient and cause less disturbance to the plans. Mr. Gary Chan, Deputy Chairman. Thank you. I have one inquiry. The other is a question. Now, inquiry. When unlawful drilling endangers national security, it would carry a harsher punishment. Our existing legislation prohibits people from manufacturing weapons, bombs, and so on. So for unlawful drilling, it carries 7 to 10 years of imprisonment, compared with the maximum penalty for making bombs and guns. Are the punishments comparable? Second question, concerning those who engaged in unlawful drilling to endanger national security, there must be a covetousness in this. They will not blatantly or firstly conduct drills to commit treason. Now, let's say if 2 or 3 people group together and form a gun club, then under subclause 8B, they claim that this is just a cause for leisure or athletic purpose. So the trainees can learn how to shoot a gun, and they can put it into practice in a treasonous act. For example, in the 9/11 incident, those terrorists claim that they learned to fly a plane as a hobby, but in the end, they drove the planes into the buildings. So when a gun coach teaches the trainees to shoot a gun, the person might not know the intention, and in the end, training is provided to the trainees. So would it prejudice the gun club or the rifle association, or the gun club? Would there be a defense for the coaches. Secretary, the first part of the question should be answered by the DOJ whether the punishment is comparable. It's okay, I can answer the question as well. If you look at foreign cases, say in Australia, the maximum sentence is 20 years, in Canada 5 years, the US 10 years, the UK, for those who provide training 7 years, for those who receive training 2 years, Singapore 5 years and 1 year, respectively, for the trainer and the trainees. So 7 years should be appropriate. Besides drilling, there is another offense for possession of offensive weapons. Second, the lawful provision of drilling by a gun club is legal. If a trainee applies it to a criminal act, while we seek to regulate the unlawful drilling, if a drilling itself is lawful, but the participant makes use of what he learns from the drilling for criminal purpose, that's another thing. So if a police officer, a police trainees receive training from the police school and he uses the skills in unlawful acts, that's his problem. So what about the comparability of punishments compared with other similar offenses, say possession of firearms? Ms. Daphne Siu, thank you. We have the Cap 238, the firearms or ammunition ordinance for unlawful possession of unlicensed possession of those, and the penalty is 14 years. Now, for unlicensed possession of ammunition, 10 years. In short, unlawful possession or unlicensed possession of firearms carries a 14-year sentence. Unlawful drilling here only carries a 10-year sentence. It doesn't seem proportionate. That's your view, Secretary? The element of treason is not mentioned in unlawful drilling. Correct. Unlawful drilling does not require the elements of treason. Now let's take a break. We will resume at 11:10. Thank you. That will be the next meeting.